Thank you so much. אני רוצה להודות פקולטה המשפטים בהר הצופים, וגם החברים שלי, קלוד קלין וסוזי נבות. They have wonderfully organized this conference. Donc maintenant, je vais parler en anglais. On 11th of October 2001, the Austrian Constitutional Court delivered the following ruling. Article 1, paragraph 126A of the Federal Law of the Public Procurement in the version of 1997 is held unconstitutional and annulled. The annulled provision shall not be applied anymore. The Federal Chancellor is due to immediately publish this pronouncement in the Federal Gazette. Nothing seems more banal today than an annulment of a legislative provision by a constitutional court. Public procurement law may indeed present lots of problems of constitutionality. The details, however, may appear a bit more surprising. Section 126A of this law reads as follows. Constitutional provision. The provisions of state law in force on January the 1st, 2001 concerning the organization and competencies of organs having the mission of providing... Pfersmann, I have 20 minutes. So, please, either you give me more minutes or I speak quickly. But not both. That's a logical problem.
I think it's only a logistical problem.
Okay. The provisions of state law in force on January the 1st, 2001 concerning the organization and competences of organs having the mission of providing legal remedies in the course of public procurements are not unconstitutional. End of quote. And this is the main statement in the opinion of the court. I quote, "This provision of section 126A was evidently conceived of as having the effect to leave all state provisions concerning the establishment and mission of the control of public procurements comprehensively free from any constraints of federal constitutional law. In other words, not to have the federal constitution applied in any such provisions. For whatever the provisions of state law concerning the establishment and mission of the institutions of control of public procurements would have required on 1st of January 2001, they would not have to be considered unconstitutional. Thus, the federal constitution would have to lose its function as limit for the state legislator. This seems to be, so, end of quote. This seems to be the first annulment of formally constitutional provision by a constitutional court in a European country. We know that the French Constitutional Council said that, quite on the contrary, the term laws in the Constitution referred only to laws adopted by Parliament and therefore excluded his competence in matters of checking the constitutionality of constitutional laws. The Federal German Constitutional Court has on several occasions accepted review, but has not so far annulled a constitutional provision. But I think that my German colleague will tell us much more about this, so I leave this outside. Italy, we have more or less the same statement. So in various countries, under various circumstances, judges and legal scholarship has to face this problem. The problem is first a conceptual one. Bringing the Constitution in contradiction with itself seems extraordinary and dramatic, as if the legal system would come to its own limit. How can something which supposedly is the highest norm be contrary to something even higher? So the very expression seems to be a contradiction in itself, devoid of meaning, or having only rhetoric and emotive effects. Either the Constitution had not been, in fact, the highest norm in the hierarchy, and hence it was not really the Constitution, and thus were faced with a different situation, or it was truly the Constitution, and thus the highest legal element in the system, and therefore it could not be possibly violating anything else. So this is a question for legal theory. The second problem is a problem of positive constitutional law. Once we have settled, hopefully, the constitutional problem, the theoretical problem, we have to see how concrete provisions in concrete constitutional systems settle the issue. The third problem is how rulings of courts may be assessed. So what I shall do here is, as my function usually in such convention is to be the bad guy, to present the theory of normativist positivism concerning this issue. Then trying to show you that contemporary constitutions are mainly potentially normalized polymorphic structures. Before I shall, in the last part, tell you that the real question, precisely for this reason, resides elsewhere, perhaps with some relief if time leaves so much space. So, my position in order to deal with this problem will be normativistic, or more precisely, internal or positivist normativism. That is, I consider legal norms to be artificially set by human beings and being dynamically organized, being relatively efficient and containing some normative mechanisms of enforcement in case previously set obligations are not complied with. Normativistic positivism is positivistic because it considers legal systems to be artificial objects and nothing else, independently of whether or not such objects comply with moral or non-legal normative requirements or natural properties external to those identified as pertaining to the object domain. It is internal, or more specifically normativistic, insofar as it considers as legal only such objects which are identifiable as norms according to something which is already considered a norm of the system. So we will be mainly concentrating on the consequences of this elementary property. The main difference between positivism and non-positivism consists in the fact that it excludes any man-made norms as artificial mind-made objects. It follows that norms pertaining to other classes of normative systems like morals, games, politics, manners, etc. are, ceteris paribus, not part of legal systems. It may be, of course, and it so happens that norms motivate the lawmaker, but motivations are not norms. There may be usually competing systems of morals, and the lawmaker chooses one of many incompatible possibilities. And moral norms, even if they are translated into legal systems, they have to be translated according to the specific techniques of legal systems. So even though the term moral may appear in legal language, this does not make a legal norm moral. The aim of this is not to exclude moral questions, but quite on the contrary, to give a space to moral questions as being precisely external to legal questions. It gives the possibility to appreciate from an external point of view what the law is. But for this we have first to identify the law according to its internal criteria. Positivistic normativism does not state, however, as one can often read, that one ought to do what the law requires, because what one ought to do in and of itself remains, of course, a moral problem, And again, for this we have first to know what the law requires in order to get a moral take on what we do concerning what the law requires. So the main objective of anti-positivist conceptions consists precisely in not separating different classes of normative systems. And why do they do that? Well, because that permits to overturn the closure of systems. Of course, this would lead immediately to a problem because it becomes either trivial or logically inconsistent. It becomes trivial if you say that every normative system is a system of every different kind of normative systems, because that would mean that in law there is everything. So I don't think this is very interesting. Anti-positivist conceptions are mainly logically inconsistent as far as they normally say that some things of positive law are indeed law, but other things, mainly what is morally interesting according to their own take, may equally be within this. But even if the whole of morals would be within law, you could still say, well, how do we appreciate the law so defined? So I think it's better just to speak about systems of type Y against systems of type Z, because it de-emotionalizes the issue. Another reason is that for distinguishing strictly those structures is that judges, especially constitutional judges, of course, try and take pains to be just, and therefore to confuse either their political ideologies or their moral theories with the content of the constitutional system. So from my take, this is not an answer to the problem. I also exclude legal realism, i.e. the view that only effectively enacted and enforced decisions or efficient regularities of behavior are law. It negates indeed the normativity of law and identifies it with facts, and then it is unfortunately unable to specify the constitutive properties of legal decisions or other behaviors against non-legal ones without introducing precisely those normative criterions which they purport to exclude. So this means that judicial rulings about unconstitutional constitutional amendments, to take the title of this conference, don't prove anything for or against the legal existence of such entities. It only proves the fact that courts have said that some such things exist. So if this is admitted, and of course you all admit it, we can now say that the legal system is dynamically structured, it is recursively structured, and it organizes its own modification as well as normative relations between norms in the relevant system. A normative system is dynamic. That means that the passage from the more abstract and general level to the more concrete and particular level requires a particular normative act and does not just happen by reasoning. This is the difference to a static system. In a static system, you just need to reason. That's the strength and the weakness of moral systems. Recursivity means that legal norms are identified as belonging to a legal system through another set of norms which already belongs to the legal system. So if this is the case, i.e. if we have a norm which permits us to identify another thing, an act consisting in a prescriptive sentence as a norm of the system, then we shall say that this is higher in the order of production. For short, because we lack time, I shall just say HP or LP if it's lower in the rank of production. So HP norms organize categories of norms through structures of and procedures of production. So once prescriptive propositions is a norm of a system, it is embedded in normative relations with other norms of the system. It can then be relatively stronger or relatively weaker, definitively stronger and definitively weaker. according to whether it prevails in the first or prevails in the last place against another norm. This shows that in all organized and developed dynamic systems, we have a difference between validity and conformity. That is, everything which is produced according to the norms of norm production is by hypothesis valid, but it may contain some deficiency, and it contains some deficiency if the law organizes the fact that certain properties in a valid norm are the conditions for another organ to annul, modify, or disapply it with respect to the exigencies of another norm. So if this is the case, then we have something which is higher in rank with respect to derogatory force, or D, or HD, or LD, if it's higher or lower in derogative force. So in this double meaning, and only in this double meaning, and not only in the first one, as one can often read, legal systems are hierarchical. So which norm prevails against which other norm, and in what manner, is therefore a question of positive law. If there are no norms specifying the consequences of an eventual deficiency, then a valid norm has no deficiency, in the meaning that it could be annulled, corrected, or disapplied. It then follows that the relatively more concrete case will be settled by an LP, a lower in production rank norm, even though it may plainly contradict the HP norm. This structural mechanism can be called the paradox of concretization, insofar as it runs against the usual idea that whatever is higher in the order of production prevails on whatever is lower. Norm production here refers to the conditions of validity, but it may be that one set of norms just states that certain prescriptions shall not be produced, or that certain already existing norms shall not be modified. Such structures raise several questions. We have heard about it just several minutes ago. So that's what you call usually eternity clauses. But in my view, this is just a HP restriction on norm production. The question then is whether some such thing is possible. The second problem is, what are the consequences? There are mainly, as always, three possibilities. Either there are no consequences in derogatory terms, or whatever goes against the prohibition lacks validity, or there are procedures to annul, correct, or disapply what is violating the ban. So, the main structural problem of all legal systems is thus the following. Does a relation of superiority in production between two given classes of norms entail a superiority in derogatory force? And this is not a theoretical question, it is a question of positive law. We can then introduce now very quickly what I mean by constitution. I distinguish the material constitution as being the set of norms of norm production from, to make it quickly, the formal constitution, which is really just formal, as everything which is produced according to exigencies stronger than those related to the production of formal legislation. So this allows restructuring and strengthening legal hierarchies. Oh, 3 minutes.
No,
okay.
I'm preparing myself.
Okay. So at that point we can quickly deal with two problems. That is that traditional legal scholarship, and Claude Klein spoke about this, mainly considered for a very long time constitutions as having only one form. I call this the monomorphic conception. But of course, whether there is only one form or many is a question of positive law. I call systems where you have many forms above and HP forms above legislation or supra-legislative forms, polymorphic systems. Of course, we shall distinguish the problem of textual unity from the problem of formal unity, but I don't dive into this now. One can, of course, narrow down the definition of constitution to say that it contains necessarily only one form, but still the problem will remain. And if the problem would be defined in such a way, then we would have no stuff for the conference. So I prefer the polymorphic conception. Polymorphism is equivalent or non-equivalent. For instance, in the American Constitution, we have a very interesting set of equivalent polymorphisms. So the Congress, whenever 2/3 or both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures. This is typically not strictly polymorphic in the sense of a difference in the rank, but just in the way in which the same rank works. So the interesting case for our purpose is non-equivalent polymorphism. And non-equivalent polymorphism is open or positive, or it's closed and negative. Non-equivalent open polymorphism seems to have first been developed in Switzerland, where the Constitution distinguishes between partial and total revision. This model has been adopted by Austria and Spain. Everything can be modified, but not in the same way. When non-equivalent polymorphism is negative, certain things can be modified, but not others. This model seems to have been first introduced in the United States at the end of Article 5. No state without its consent may be deprived of its equal suffrage in the Senate. This method has since then been adopted, so we have in the United States both equivalent monomorphism and some form of non-equivalent negative polymorphism. This method has since then been adopted by France in 1884 in order to prevent the return to monarchy, and famously developed by Germany in order to sanctify the principles and fundamental rights, representative democracy and federalism. Italy followed France in 1947, and Portugal seems to have extended the German conception. You have a whole list, Greece, etc., many other countries.
I don't think in Europe.
Well, there are other countries than in Europe. And my chairperson will not allow me to speak about too many countries, as I have 3 minutes left. So the question is whether one can say anything about the presence or absence of derogatory consequences in the absence of explicit provisions as a matter of positive law when there is a difference in HP forms. My thesis is that this is a problem which cannot be settled by a normativist framework alone, because it shifts us to the question as to what exactly the provisions of positive law mean. Therefore, the real problem is a problem in the theory of interpretation. Now, in the theory of interpretation, we are again faced with, I would say, 3 varieties. Either jurisprudential realism, I have already dealt with this. I don't consider that when just a court states that something is in a certain way, this is a proof that things are in a certain way. It just proves that what courts have said. The second theory is what I would call structuralism. Structuralism is a reduced form of the theory of the hierarchy of norms. That is the idea that when you have a differentiation in forms, that is some form of polymorphism, then this necessarily entails certain consequences, either that the consequences are irrelevant, negative structuralism, or positive structuralism, which means that whenever you have this difference, then it entails that courts be entitled to check norms against higher constitutionality. I think this is not sufficient. So, unfortunately, this brings us back to the real problem, which is the problem of interpretation. This opens up a whole ocean and the box of Pandora, where I have just 1 minute left. So let's just revert for the end to concrete cases. For instance, I would say that the Austrian Constitution of 1920 distinguishes polymorphic, non-equivalent structure, but without the consequence in the first setting of constitutional amendments to be checked against higher constitutional law, simply because these are just two HP techniques. The thing changes, I would say, and this is really a question of controversial interpretation, after April 1945, where the Austrian Constitution is anew enacted as being something which has a fundamental take against the Nazi system and the dictatorship in the between two war periods after 1934. Therefore, and then it reflects the fact that there was a whole work on reinterpreting materially the strictly formal textual conception of polymorphism. Therefore, I would sustain that indeed, even though the opinion of the court seems to me really not elaborated enough, that the Austrian court was justified in annulling the said constitutional amendment. I would say the same for France. I would say that after August 1944, the conception of the Republic is a different conception of Republic than the one which was introduced in 1884. But again, this is a problem of interpretation, and therefore we have to organize another conference on the theories of interpretation. Thank you very much for your attention. Haven't too much exceeded?
No. Thank you very much, Otto. That was well done. And I must also emphasize that this roundtable is not over, that we will continue the discussions and you will have the chance to contribute. Personally, I would love to hear more, as I also support the positivist normativist approach, while then recognizing that we need to address the techniques and we need to discuss how then we reflect upon morality and other important issues, besides being positivists and normativists. I move now to Professor Ulrich Preuss, who is introduced in our program as going to be presenting another approach. That leaves much room, because the space taken by Otto Pfersmann was fairly narrow and leaves many different approaches to be tackled. Professor Preuss has mainly worked in the academia in Berlin, Bremen, and elsewhere, but also has made excursions into the realms of constitution making and constitutional adjudication. So we will benefit from your rich experience.
Thank you very much. First of all, to be sure, the title of my speech does not come from me. So it was, I think it was simply the result of the fact that I failed to give an appropriate title, and then the conveners somehow had to find something, and then that's what they did. But in a way, I mean, having listened to what Otto Pfersmann just mentioned, you have learned that the internal view on this problem of unconstitutional constitutional amendments is a highly complex issue, and I hope to lower the complexity of what we are going to discuss now by taking a more external view on the issue. Claude Klein, who has started this morning with respect to the substance of our topic, gave his speech the title of "The Modernity of Constitutional Question," and I think he gave a convincing argument for the fact that, in fact, it is a contemporary, essentially urgent problem. I want to start with a political understanding and a political interpretation of the issue which you are discussing. And here, many things were already briefly addressed by previous speakers. let me come back to the Weimar Constitution, which was mentioned already. The whole debate, I think, goes back, in fact, to the debate about Article 76 of the Weimar Constitution, which allowed a constitutional amendment of the Weimar Constitution by a mere two-third majority of the Reichstag, the Diet, which means that the constitutional amendment was just a law, a statutory law, as every other law, but with a simple qualification that rather than a simple majority, you need a two-thirds majority for changing the constitution, and by a purely formal and positivist interpretation, that would mean that in fact the Republican form of government of the Weimar Constitution could have been reversed and replaced with monarchy by a two-thirds majority in the Reichstag. Given the fact that, and that was the starting point of the famous distinctions of Carl Schmitt, which was also already mentioned by Claude Klein, given the fact that the Weimar Republic was a multi-party system, which means that coalition governments were the rule rather than the exception, that the majority, the simple but also, of course, the two-thirds majority of parliament consisted of very diverse political forces, maybe ranging from the extreme right to the extreme left, and even some parties from the center, in order to pursue a certain political goal. They were more or less coalitions rather than basic political concepts which held together these groups. And the fact then was that very arbitrary majorities could change the basic substance, so to speak, of the constitution by merely assembling two-thirds of the members of the Reichstag for that kind of amendment. That was the scandal, so to speak, which Carl Schmitt was the first one who dealt with that question and developed this famous distinction between the constitution as a law, as a merely kind of legal statute, which originated in the constituent power of the people, but still it was a law, and the substance of the constitution, the essence. And he said, well, these two-thirds majority, this two-thirds majority requirement for the amendment, this applies certainly without any qualification to changing the law, the constitutional law, but changing the substance of the constitution was a different thing, and his idea was to protect, so to speak, the substance. At least that's what he claimed to do, to protect the substance of the Weimar Constitution against right-wing or left-wing revolutionary changes, which he somehow saw in the parliament. In fact, it was somewhat different, and here I disagree also with the interpretation which my dear friend Claude offered this morning. And he, by the way, also after World War II, and I will come to Article 79.3, of course, of the German Basic Law, when people said, well, look, the fathers and the mothers of the German Basic Law, they more or less learned from Carl Schmitt and his claim that the Constitution and the substance of the Constitution has to be protected against more or less arbitrary majorities which may assemble in the parliament. The political intention of Carl Schmitt was different. At least this is my interpretation, because he did not claim that a two-third majority within Parliament was not enough in order to change the Constitution. He did not claim really the eternity of the Constitution, because otherwise, then in 1933, which was also mentioned, he would not have easily applauded to a fundamental change and the transformation of the Weimar Republic into the fascist regime. The very idea was to find an institution which was able to identify with the political substance of the Constitution, which had the monopoly of interpreting the Constitution. In this respect, Otto Pfersmann is right when he says this is one of the key, I don't think this is the question, but it's one of the key questions, the interpretation question. Which political force is legitimately called upon identifying itself with the Constitution and with having the authentic and authoritative interpretation of the Constitution. That was the issue. And Carl Schmitt's answer was, the first answer was, who, in other words, the question of who is the guardian of the Constitution. The whole question about identity of the Constitution, the whole question of whether there are substantive issues which have to be protected is always about who defines what is the substance, who is the guardian of the Constitution. And that was Carl Schmitt's very idea, and his answer was, the first answer before 1933 was, it's the president. The president was the head of the executive. That means what is the political intention of Carl Schmitt was not to protect the Weimar Constitution, but it was to shift the political power from parliament to the executive, to the president. This was the background, so to speak, of that very, of course, very convincing interpretation which he gave by inventing, so to speak, or by finding out that there is a difference between the law of the Constitution on the one hand and the substance, the essence, what today we call the identity, and he used a different. He said that's the political substance. But it was from the political point of view, and I think we have to look at this. Whole issue of our conference from a political point of view. From a political point of view, it was just a shift from the parliament, which he thought was not really democratic, although it was representing the people, but it did not really represent the substance of the people. That means what he, as a German conservative, he never believed that parliamentarism and the plurality of parties would be able to represent the people. So, in other words, to disempower the parliament and to empower the president, that means the executive branch. That was before 1933. After 1933, so he could always claim more or less I was consistent in my theory, then another guardian, in quotation marks of course, another guardian of the Constitution was found, namely those who could claim to embody the people. And that was, of course, the Führer. That was Adolf Hitler and his Nazi movement. They claimed, we are the German people. They didn't say, we are just a party and we take over the power. No, we the people. They said, we are the people, we are the German people. We embody the German people, and therefore we are legitimized to take over and to take over the power. And Carl Schmitt, then, as we all know, he justified this takeover of the Nazis because he could say, well, they embody the German people, the substance of what the German people really wants what is, so to speak, the embodiment of the constituent power of the German people. In other words, this formula, and to come back now to the more abstract implication and consequences of this distinction, I think the formula which he coined and which is up to our days, at least in Germany, widely accepted, gives rise to a very dangerous political consequences. In that the shift from those institutions which, by the former constitution, are empowered with the use of the constitutional power, that they can be disempowered by whoever then has the power, the factual power, or the normative power in terms of ideology or philosophy or whatever they may claim, disempowered by other forces which can claim that they are the real and authentic interpreters and guardians of the Constitution. And therefore, I think I reject that very idea of this distinction, which was established by Carl Schmitt. But on the other hand, he really raised a legitimate and right question. Otherwise, this conference wouldn't take place. I mean, that is quite clear. Now, and that leads me now to Article 79. I wonder whether I looked at my watch. You tell me 5 minutes earlier.
You
okay?
still have 10 minutes.
Okay. So that now leads to Article 79, Para 3, which was mentioned here several times, and which says amendments to this basic law affecting the division of the federation into Länder, their participation in the legislative process, or the principles laid down in Articles 1 and 20, not 1 to 20, which is frequently read, 1 and 20, shall be prohibited. So the prohibition of certain certain amendments. And then, as I said, in Germany, and maybe also outside, because many non-German constitutional lawyers certainly learn and kind of receive, of course, their many ideas from the German doctrine, make the claim that Article 79, Para 3 is exactly, so to speak, the codification of what Carl Schmitt then proposed. And he himself, as I said already, after World War II, when he somehow had to clean himself, then he also said, well, look, I was the true defender of the Weimar Weimar Constitution because I made this distinction about which I spoke. But that's not true. The basic 79 Para 3 has a different meaning, pursues a different purpose, namely, and that is obvious. I mean, I don't have to elaborate on that. Obviously, the idea was to prevent a situation of 1933, and that means, you know, the Nazis claim. I don't think the claim is justified, but many people believe the claim of the Nazis that they came to power by means of legality. That was a legal way of coming to power, and by just making use of the instruments which the Constitution provided, namely the Weimar Constitution provided, and therefore Article 79, Para 3 was intended to prevent this the repetition of this kind of regime change. The change from constitutional democracy towards dictatorship and totalitarian regime. That was the very idea. So to prevent the legality of a regime change, which would abolish constitutional democracy. This is the very idea, which then gave rise also to a new understanding of the German basic law, and there are some other, not very many, but some, I think, other constitutions in the world which follow this path, namely the very idea of militant democracy. You have heard about this. This is a term which was coined by Karl Lowenstein, a German immigrant who then published and became an American scholar. Militant democracy, meaning that democracy is not just a system of rules, but it is an embodiment of certain values which must be protected, and there should be institutional devices which allow that protection. And you know, in Germany we don't have just Article 79.3, we have also Article 21, the prohibition of political parties, and other rules, which as a whole constitute the very idea of militant democracy. Now, and that is something different than the Carl Schmittian idea. Just for clarification, I started with that. Now let me come to my second point. That is to the very logic, so to speak, the inherent logic of Article 79, Para 3. First of all, I agree to what Otto Pfersmann said. From a purely internal logic of the legal logic, so to speak, of a constitution, something like an unconstitutional constitutional amendment is not possible. It's not conceivable, because as a constitutional amendment, then once it has been inserted in the Constitution, has the same rank as the Constitution. There can be no contradiction between the different norms which are not, which do not find themselves in a hierarchical relationship. But things are a little bit more complex. In this respect, even more complex than the purely internal view on that issue, and that is addressed in Article 79. And before I come to 79 Para 3, I should also mention, which was not yet mentioned, this is this Article 79, Paragraph 1 of the German Basic Law. This says, this basic law may be amended only by a law expressly modifying or supplementing its text. So that is a purely warning function. So it does not establish any kind of limits to the amending power. It is a limit. It's a procedural limit, saying whenever you want to change the constitution, you have to explicitly put it into the text of the constitution in order to make clear that the constitution is not just the embodiment of all the rules which have been enacted by a 2/3 majority. We need the text. The text is the basis, so to speak, of the constitution. The textuality of the constitution is essential, and therefore this amendment has to be codified in the text. But this is a merely procedural obstacle, which is not very strong in order really to prevent major changes which some majorities in the parliament may aspire. Now, to explain the sense of Article 79.3, let me just briefly make a thought experiment, namely to say what would happen if 79.3 would not exist. Now, then, first of all, and there are rules about constitutional amendments. The normal rule, and I now speak again from the German perspective, because we have different powers, different institutions which have the amending power. I speak now from the German case. The German case means that the regular parliament, our Bundestag, the Diet, not the Diet, but the Bundestag, the federal parliament, has the power to amend the constitution by a 2/3 majority, and there's still then the Bundesrat, the federal chamber, which also has to amend, which also has to enact it with a 2/3 majority. Now, given that situation, then if there's a requirement of 2/3 majority, then the thing is quite easy. If you want to amend the constitution and you don't reach the 2/3 majority, then no amendment occurs. So no possibility. You cannot insert a rule which has not reached the 2/3 majority, and that means no unconstitutional constitutional amendment is possible. This is not the issue which is interesting. The more interesting issue is if you have an amendment which is problematic content-wise with respect to its substance, to its content. And now, let me just give an example. For instance, the German constitution contains the protection of the integrity of individual life. So the protection of life is one of the major human rights guarantees in the German constitution, the basic law. And now suppose there's an amendment according to which into the juridical system of the Germany, as one of the sanctions in criminal law, the death penalty is drafted in a law, in an amending law. Now, and I speak about the situation when 79 does not, if this norm did not exist, what would happen? Well, what do you think? I think this amendment, if it reaches a 2/3 majority, the death penalty would be introduced into the constitution, with the result that two inconsistent elements would be part of the constitution. First of all, protection of life, of individual life, unconditional and unqualified. On the other hand, you have the death penalty. Obviously, this is inconsistent. Now, would an inconsistent element of the constitution invalidate the amendment? The answer is no, because the invalidation would require that there is a superior law which defines the rules according to which one law can become law. And if this is not the case, then the constitution has an inconsistent content, but they would coexist. The two rules, the two contradictory rules would coexist. And you would say, well, doesn't that undermine the constitution? And the answer is, well, it depends. I think it's, and here again, I think what Otto Pfersmann said as the key question is correct. It's a matter of interpretation. It's a matter of those who are empowered with the power of interpreting and applying the constitution. They have to find an interpretation according to which the consistency of the constitution is maintained But what is important for the topic of today is there is no unconstitutional constitutional amendment without Article 79, Paragraph 3. Now, let me just make a brief excursion to the question which was raised by Otto Pfersmann about the question: could and we speak about the Constitutional Court in Germany. Could the court invalidate? Yes. Could a court invalidate an amendment which has already reached, so to speak, the stage of the Constitution, which somehow has become part of the Constitution? For instance, this death penalty issue. Certainly it could not, because the court has only, so to speak, the standard and the measure and the standard by which it has to measure is the Constitution as such, and the court itself is the creature of the Constitution, so they are not above the Constitution, so they cannot do that. Now, still, to tell you just the mechanics, so to speak, the technicalities, the things are different in Germany. Now, if such case came into reality, the death penalty case, then there would be a group in the parliament which would then submit this draft, give it to the president of the Bundestag, and say, well, we want this amendment to be enacted by the parliament. Please submit this to the parliament, and we are sure we get the 2/3 majority. Now, what does the president do? The president says, well, I do not allow that, because I think this would undermine the integrity of the Constitution, or it would render the Constitution inconsistent. And I think an inconsistent Constitution somehow weakens the Constitution. It is somehow it is anti-constitutional. So that would be at least a claim what he I think would be. And then, of course, then this group would say, well, but we insist. And if they can't find a consensus, so then the conflict has to be submitted then to the Constitutional Court. And the result will be that then the Constitutional Court will make the decision of whether this amendment can be submitted to the Parliament and could then pass the procedural rules or not. So this is the result from a purely formal point of view, which leads me to the. Unfortunately, I have still many other points which I would like to raise, but we have time in the discussion, of course. I hope leads me to the question that. And here, this is difference to what Otto Pfersmann said. I don't think that interpretation is the key question. That the key question is who is the guardian of the Constitution? Who has the power to decide what is the substance, so to speak, the essence of the Constitution, which has to be protected? That is, I think, the key question. And there's another question, and that would be the second half of my talk, if I had the privilege to amend the constitution of this conference unconstitutionally, to just take the word for further 20 minutes. But of course, I am not allowed to do that. The chair will then prevent that, just as the president of the Bundestag would do that. The question is, of course, then, is there a need for the idea of the identity of the Constitution, for the substance, in order to be protected? And I would give a skeptical answer, knowing that Michel Rosenfeld, who's just sitting in front of me, has just written a book. I saw that outside, a book about the identity of the constitutional subject. That would give us certainly much stuff for controversial discussions, but I have to leave that to later discussion. Thank you very much for your attention.
Thank you very much, and I thought you were quite consistent with yourself by referring to the historical evolution of thought in Germany, and I think what you said at the end matches with the way you describe the events, indeed. Now we have concluded the round of presentations, and we have the floor open for discussion, and we have a bit more than half an hour before the lunch break. At this point, I would like to remind the participants that we have simultaneous interpretation between French and English, and therefore they need to speak to the microphone. Also, I want to inform them that the organizers are videotaping this conference, and if you want to refuse your contribution from appearing in the webcast, then you should say it when starting. It's maybe best that people speak from here. Bertrand Mathieu, you are the first.
Oui, merci. Je serai très bref et donc nécessairement un peu caricatural. Lorsque Claude Klein a commencé sur la question de la modernité du problème, je crois qu'il a tout à fait raison. L'une des questions qu'on peut se poser à propos de cette modernité, c'est de savoir, au-delà d'une situation qui est en effet nouvelle, et on l'a vu dans les exposés, c'est pourquoi ou qu'est-ce que traduit la nouveauté de cette situation. Probablement traduit-elle finalement la fin d'une époque, c'est-à-dire la fin de ce que l'on appelait traditionnellement le système démocratique. Alors je sais bien que par une facilité de langage, on appelle aujourd'hui démocratie la protection des droits fondamentaux, mais la démocratie et la protection des droits fondamentaux, c'est deux choses différentes, tout au moins par rapport à la conception traditionnelle de la démocratie fondée sur la souveraineté du peuple. Je crois que finalement, peut-être, on ferme une parenthèse. On ferme une parenthèse qui date, alors en France, de la fin de la Révolution. À la fin de la Révolution, à la Révolution, en France, on se méfie essentiellement du juge. Pourquoi on se méfie du juge? Parce que les parlements d'Ancien Régime, c'est-à-dire les juges, ont voulu s'opposer au roi souverain en invoquant quoi? Une loi naturelle, un système de valeurs. Et je crois qu'aujourd'hui, on en revient exactement à cette situation, sinon que le système de valeurs n'est plus un système de valeurs religieux, c'est un système de valeurs fondé sur les droits fondamentaux, et il a été amplement démontré ce matin, notamment dans la deuxième intervention, que l'on renvoyait à des valeurs, on renvoie à des principes universels. Et qui est le gardien naturel de ces principes universels? C'est le juge, nécessairement. Et donc je crois que finalement, d'une certaine manière, on referme la parenthèse de la démocratie, qui n'aura été que brève dans l'histoire de nos systèmes politiques, pour arriver vers un nouveau système qui est peut-être mieux, qui est en tout cas différent, que l'on peut, si l'on veut, appeler démocratie, de la même manière qu'on peut appeler chaise une table. Merci.
Merci. Thank you very much. At this stage, I have recorded 7 requests for the floor. We have also the 4 speakers who presented papers, so let me propose 2.5 minutes each, and 3 minutes each for those who presented papers. Julia, you are the first, next one, and maybe it's good that people introduce themselves to the microphone as well, so to have it on the table.
Merci, Monsieur le Président. Julia Eliopoulos-Strangas, Université d'Athènes. Je ne peux pas partager tout à fait d'abord la thèse de mon ami Bertrand Mathieu que la démocratie aujourd'hui, ce sont les droits de l'homme. Parce que quand même, ça reste, la démocratie, c'est un principe d'organisation de l'État aussi. Et je trouve qu'en dépit de tous les défauts, c'est le meilleur. Alors, les droits de l'homme, c'est une partie, mais une partie substantielle. Mais on ne doit pas perdre des yeux que la démocratie, en principe, c'est un principe d'organisation. Tout d'abord, j'aimerais encore illuminer un peu le problème de l'Union européenne. Concernant l'amendement de la Constitution, peut-être mon ami Galis qui va parler de la Convention européenne des droits de l'homme, mais pour les pays membres de l'Union européenne, il y a un grand problème, puisqu'il y a un amendement tacite de toutes les constitutions, même dans des lieux qui sont exclus de tout amendement. Je parle de la constitution allemande, je parle de la constitution grecque, qu'il y a aussi à peu près la même formule que la constitution allemande 79 et 79. Et j'ai évoqué à mon ami Otto la constitution hellénique parce que là, il y a une formulation tellement vague concernant ce qui ne peut pas être amendé. Entre autres, parmi quelques droits fondamentaux qui sont cités expressément, il y a aussi la forme et le fondement du régime en tant que démocratie parlementaire présidentielle. Alors, vous pouvez là interpréter tout ce que vous voulez, qui ne peut pas être changé, et c'est une question, bien sûr, de l'époque politique où cette disposition doit être appliquée. Et puis, un dernier point, je ne veux pas maintenant abuser, l'amendement peut-il être contraire à la Constitution? Là, nous avons à pondérer deux éléments, le principe démocratique et puis l'identité constitutionnelle. Mais quand même, il y a deux choses qu'on doit prendre en considération. Est-ce qu'une génération peut lier les générations qui viennent? Ça change. Alors, est-ce qu'on peut accepter de clauses éternelles, disons? J'ai des doutes. Et d'autre part, ça se peut que même sans ces clauses, il y a des amendements qui sont contraires à la Constitution. Et c'est le dernier point de vue. Il y a par exemple dans la plupart des constitutions la protection de la dignité humaine. Et cette protection de la dignité humaine, à mon avis, met des limites à tout amendement de la Constitution, même tacite. Alors là, je pense qu'on doit y réfléchir un peu parce que ça pourrait qu'il y a des amendements qui paraissent d'une première vue permis par la Constitution, de tout point de vue, mais qui quand même contradictent à la protection de la valeur humaine. Je vous remercie, seulement pour réfléchir.
Dominique Turpin, Université d'Auvergne, France. Je vais parler français moi aussi parce que si je me risque à parler anglais, l'interprète devra traduire mon anglais en vrai anglais et puis le traduire ensuite en français. Je voudrais dire d'abord ma réticence a priori devant l'idée qu'un amendement à la Constitution puisse être inconstitutionnel. Peut-être en cela suis-je très français avec cette réticence depuis longtemps envers les juges à laquelle Bertrand Mathieu a fait allusion. Et je suis par exemple très réservé devant la clause qui date de 1884, qui figure à l'article 89 de notre Constitution, qui interdit de revenir sur la forme républicaine du gouvernement, pour toutes sortes de raisons. D'abord parce que ça ne nous empêche pas d'avoir des monarques élus depuis très longtemps sous la Ve République. D'autre part, parce que si demain le peuple français souhaitait revenir en monarchie, je ne vois pas très bien comment, ni d'ailleurs de quel droit, on pourrait l'en empêcher. Et ensuite parce que je considère que la République, c'est peut-être davantage qu'une forme de gouvernement, un ensemble de valeurs, ce que nous appelons notre pacte républicain. Et donc je me félicite de ce que notre Conseil constitutionnel, en mars 2003, ait refusé le contrôle qu'on lui demandait lorsqu'on a inscrit dans la Constitution que la République était décentralisée. D'une part, je crois que sur le fond, la République peut très bien être décentralisée. Il ne faut pas confondre la forme républicaine et la forme jacobine du gouvernement. Une minute. D'autre part, moi, je ne crois pas qu'il puisse y avoir de normes plus constitutionnelles que d'autres. En revanche, il y a peut-être parmi les normes constitutionnelles certaines qui sont plus fondamentales que d'autres. Et alors, il y a un mot que je n'ai pas entendu prononcer ce matin, et c'est la question que je voudrais poser aux orateurs ou à ceux qui voudront bien s'en saisir, c'est le mot supraconstitutionnalité. Et est-ce que finalement, pour justifier l'idée que des amendements puissent être contraires à la Constitution, il ne faut pas passer vers cette notion de supraconstitutionnalité? Est-ce que c'est les clauses éternelles dont on nous a parlé? On a le souvenir de constitutions où on nous disait que le caractère socialiste ne pouvait pas être remis en cause. Elles ont eu fort heureusement une très brève éternité. Est-ce que c'est la Convention européenne des droits de l'homme dont on nous parlera cet après-midi? Mais est-ce qu'il ne faut pas, est-ce que nous ne sommes pas condamnés à passer par cette notion vis-à-vis de laquelle je suis personnellement, en tant que juriste, assez réservé, de supraconstitutionnalité pour expliquer que des amendements constitutionnels puissent être contraires à la Constitution? Merci, Monsieur le Président.
Thank you. The next one is Vicky Jackson.
Thank you very much. Terrific panel this morning. I'm Vicki Jackson. I teach law at Georgetown University Law Center in Washington, D.C., and I have had the privilege of being involved with the International Association for some years. I have a comment and a question. The comment is that in thinking about unconstitutional constitutional amendments, I offer an alternative vocabulary to the very interesting categories we heard this morning. Amendments might be unconstitutional on procedural grounds if 2/3 are required, but somewhat less than that approve, a court might quite permissibly say the procedural requisites have not been met. Substantive unconstitutionality poses the more difficult question, and that is what most of the remarks have been addressed. I want to suggest that the procedures of a state like California, which was referred to earlier, might suggest that there is a quasi-substantive form of procedural review. That Constitution says that for something called an amendment, certain minimal processes, including popular initiative, are required. 51% is the rule. For something called revision, popular initiative is not required, and either a convention or a legislative proposal is required by a slightly higher vote. When the court chooses which procedure is appropriate, substantive values about what is essential or core to the Constitution inform that choice. So that is my first suggestion. My second suggestion, it turns out, is that we might think of three sets of concerns or norms as informing judgments with respect to unconstitutional constitutional amendments. First is rule of law positivist kinds of values about which we've heard much. Second is democracy and consent, about which we have heard something. And third is the idea of right values or principles, which I will suggest might be informed by transnational concerns and by the fact that constitutions are always designed to constitute their nations in the community of nations. My question for Professor Weinthal, who made such an excellent presentation this morning, I wonder at your third track, as you described it, how it could possibly apply in a polity like the United States that was founded by an unjust and exclusionary body. If in the United States we were required to get majorities in the divided communities at the time of our Civil War, the 13th, 14th, and 15th Amendments would never have been adopted, because the power holders in one part of the polity would have been opposed to that. So I want to suggest that the conditions for your third track might be somewhat limited, and I want to ask you whether it isn't possible to have 4 or 5 tracks of lawmaking, as some modern constitutions, I think, provide. Thank you.
Thank you very much. You have the floor.
Uwe Kichel. I teach law at the University of Greifswald in Germany. I have 2 comments. The first one is rather short. When Professor Preuss told us about the logical inconsistencies, I could not quite follow him, because the inconsistency consisting of the fact that a law that changes the Constitution is also constitutional and therefore on the same level as the Constitution, and therefore an unconstitutional constitutional amendment is impossible. And you said that is what Professor Pfersmann said too. I don't quite know that. I would add to that or contradict you by saying that any provision in a constitution that mentions the unconstitutionality of a constitutional amendment, material unconstitutionality, by itself means that there is an internal hierarchization of norms within the Constitution. Those norms are higher. The second is a comment or a call for some modesty that comes with the difference between a revolution and a constitutional change. We have constitutional changes, legal constitutional changes, that come in this old phrase from the pouvoir constitué, and we have revolutionary changes, and they are simply extra-legal. I think in the sense of Professor Pfersmann, and I would totally agree, as a lawyer, I can't talk about them. But they are always possible, and it would be totally immodest to think that you can keep a people from changing its constitution for the next 5,000 years. Therefore, I doubt, with respect, what Dr. Weinthal told us. Your third track is basically what the pouvoir constituant does, but you are adding to that certain, as you call them, normative requirements. And I don't know where you get them. I don't see how they can be higher than the will of the people. And so I think there might be a confusion between these 2 levels. Thank you.
Thank you very much. Cesare Pinelli.
Cesare Pinelli, University of Rome Sapienza. I think that Professor Preuss has demonstrated why Schmidt's distinction between constitution and constitutional legislation has very little to do with what we are speaking about this morning. And I would like to add something to his demonstration. I think the real problem of unconstitutional constitutional amendments is not put in the case such as those of the German and the Italian constitution concerning the fact that the French or the Italian, that the Republic is not subjected to amendments, because in this case it is clearly stated. The real case is the one of implicit principles, supreme principles, which courts might believe or might clearly state to be supra-constitutional. In this case, I think we are confronted with the real challenge of constitutionalism, which is a challenge consisting in the emergence of principles which have a dimension which cannot be reduced neither to the law, nor to the facts. And just for a minute, I want to demonstrate this in a minute. I don't believe that this corresponds to the eternity clause, because the eternity clause maintains an ambition of maintaining, of course, in the eternity such principles, which is against the possibility that a revolution comes. A revolution can always come. So this is intended in the doctrine of supreme principle. The doctrine of the supreme principle doesn't contradict the possibility of a non-legal evolution. It is a third dimension which is different from the purely legal and the one consistent with the formal procedures, and the other one which is, of course, against, which is only fact and revolution or coup d'etat. Excuse me.
Thank you.
Rainer Arnold, University of Regensburg in Germany. First, our Constitutional Court several times has examined constitutional amendments on the Constitution. Article 13, Article 16A, and never annulled, but would have been ready to annul, but has said clearly that Article 13, paragraph 3, for example, has to be interpreted in the light of higher, superior constitutional norms. Then it is constitutional. If not, no. The second remark is to the distinction, of course, existing between constitutional reform and creating a new constitution. It's true, but is this really a revolutionary act? I'm convinced that also creating a new constitution is bound to some very universal and supreme values. In my view, a new constitution, whatever revolutionary could not abolish or reduce human dignity. I think this is not only a cultural condition, but a normative one. And the third one, we have in the recent jurisprudence of our Constitutional Court a certain revival of what is called constitutional identity. Apart from 79, paragraph 3, constitutional law is not only threatened by internal amendments, also by external impact of European Union law. So the Lisbon Treaty decision of our Constitution stresses constitutional identity without defining it. It's very vague and maybe undefinable concept, or not easily definable concept. Of course, it's linked a bit to Article 79, paragraph 3, but nevertheless, I think there are two new concepts. So, thank you.
Thank you very much. Avian Smith?
Avian Smith from the University of Oslo in Norway. Just a very, very short question, maybe provocative. We got the impression in this kind of discussions, interesting certainly, and modern certainly, yes, about the idea that supraconstitutional norms, eternal norms, so to say, are always positive. The values are positive. That's really what has been purported even this morning to some extent, in defense of the good thing against the bad guys, so to say. But how do we know that? I mean, how about old constitutions? My own constitution has still clauses about, confessional state. I'm not prepared to defend that to a very large extent. How about different regimes than those basically represented here? To take one that would not raise the anger of anyone, the Soviet Union. Had the Soviet Union had an eternity clause about the rule of the Communist Party, should we defend that? That would be really my very small and friendly provocation. How would you cope with that? Thank you.
Thank you for that. And you have the floor, sir.
Professeur Alexandre Viala, Université Montpellier 1. Je voudrais faire deux remarques qui pourront vous paraître contradictoires et je voudrais m'en excuser par avance, mais c'est parce que je voudrais plaider à charge et à décharge contre l'idée de supraconstitutionnalité. La première, qui est hostile à cette idée selon laquelle il y aurait possibilité d'inscrire dans les constitutions des limites matérielles au pouvoir de révision de la Constitution, c'est que l'origine de cette idée, l'origine doctrinale de cette idée, on la connaît, c'est Carl Schmitt qui a été évoqué à plusieurs reprises tout au long de la matinée. Or, l'on connaît la conception subjectiviste de Carl Schmitt. Carl Schmitt est un théoricien décisionniste, c'est-à-dire qu'il considère que c'est la décision qui fonde l'ordre juridique et non la norme, et il a notamment fondé sa distinction entre la Verfassung et la Verfassungsgesetz, c'est-à-dire la Constitution et la loi constitutionnelle, sur sa fameuse théorie du compromis dilatoire, selon laquelle l'origine d'une constitution, l'essence d'une constitution, prend racine dans une décision. Une décision qui intervient longtemps après la rédaction d'un compromis qui, par définition, comme tout compromis, n'a pas tranché sur la nature du régime politique. La nature du régime politique, elle a pu être conclue, elle a pu être tranchée à l'occasion d'une crise politique, type 1877 en France ou 1962, un peu plus tard, toujours en France. Or, cela signifie que l'origine d'un régime politique, donc son essence, plonge ses racines dans une décision éminemment subjective. Or, ça peut paraître en contradiction avec l'idée même de supraconstitutionnalité, selon laquelle il y aurait une norme objective qui transcende les décisions du législateur constitutionnel. Donc je me demande comment on peut soutenir l'idée qu'il existe des normes objectives, alors même que leur origine est éminemment subjective, à savoir la décision du chef ou du souverain à un moment donné. Maintenant, pour plaider à décharge en faveur de la supraconstitutionnalité, je voudrais revenir sur l'argument positiviste qui consiste à dire il suffit de supprimer par un simple trait de plume constitutionnel, par une simple révision constitutionnelle, la limite matérielle selon laquelle il est interdit de remettre en cause la forme républicaine du gouvernement pour se délier d'une telle interdiction. Je me demande si c'est un argument normativiste et positiviste, qui a été notamment soutenu assez souvent par Georges Wedel. Je suis enclin à me demander, depuis ces derniers temps, que cet argument est tiraillé par une sorte de contradiction performative. C'est-à-dire qu'il y a une contradiction entre le sens de cet argument et le fait entre l'énoncé qui porte cet argument et le fait de l'énoncer. C'est-à-dire comment peut-on énoncer que la limite selon laquelle il est interdit de réviser la forme républicaine du gouvernement n'est pas une limite opposable en soi, puisqu'il suffit de la supprimer, sans reconnaître qu'elle existe. Si l'on dit qu'il suffit de supprimer cette limite pour s'en délier, ça veut dire qu'on la reconnaît. Donc par le fait même d'énoncer l'existence de cette limite, on en reconnaît l'opposabilité. Ce qui est de nature à nous faire conclure que finalement, il est par cela seul que l'on prétend qu'il suffit de supprimer cette limite par une simple révision constitutionnelle, c'est qu'on en reconnaît l'existence. Donc l'argument wedelien qui consiste à dire que cette limite n'est pas opposable parce qu'il suffit de la supprimer est entaché d'une contradiction performative. Tout simplement.
Merci. Well, that concludes my list of speakers. I did my best to scribble down all requests for the floor. And now I'm not opening a new round now, but I'm asking, was there somebody I blatantly disregarded? No? Good. Thank you. Then we have the round between the panelists. And let me propose we go in reverse order. I make this proposal mainly to make Claude Klein the last thing between us and the lunch. So we start with Professor Preuss. And before you start, let me propose that we leave the issue of the international transnational dimension to the afternoon panel, because we have a paper there on that topic. So that maybe helps us to finish in time.
Well, thank you very much. I mean, there's so many remarks, and I can only choose one or two. The first one is the Article 79.3 of the German Basic Law has now also reached a dimension which was raised then by Rainer Arnold when he said, well, look, the European Union, the integration of Germany into the European Union is now also a kind of danger to the identity of the German constitution. And that is something I happen to strongly disagree with that decision of the Bundesverfassungsgericht, and because this simply, I think, is a further argument for bewaring of the power to authentically interpret the Constitution and the identity of the Constitution. The term identity, the concept of identity of the Constitution, is, in my view, just a kind of free authority to impose a certain political view on the development of the Constitution, on the whole polity. So that's just a very brief remark. Which is more important is the second question, which was raised also. What is the how can we define the inherent substance of a constitution? In my view, or what we then could call the identity, something which is unchangeable. I think there's, from a logical point of view and from a teleological point of view of the Constitution, the only point which has to be protected is the integrity of the constituent power, which means the power of the people to choose and to enact a constitution in a free and democratic manner. I think this is the only, because this is a kind of self-referential topic or self-referential element of the Constitution. So to make a constitution means that people are free to exercise their right of self-determination. Whether federalism or whether monarchy or whether republic is something which should be eternal, I think it should not, because this may change within the course of history. But what is really unchangeable, should be unchangeable, the right of the people to establish a constitution, and that includes also what Rainer also said, the dignity of human beings, because that's not, because the inherent idea of making a constitution has certain inherent logical, so to speak, teleological implications, namely that people want to live under free and under free conditions of self-determination, and that also means that what you said. I disagree strongly with the idea that within a constitution there is a hierarchy. No, if there is a constituent power which creates a constitution, that means the whole constitution is the embodiment of the will of the constituent power, and there's no internal hierarchy. I could explain also. I don't have the time. Both your cases which you raised, namely that the Constitutional Court in Germany supervised, so to speak, the constitutionality of certain constitutional amendments. I could explain to you. I will do that during the pause and not hassle the rest of the audience with that. Thank you very much.
Thank you. And the next one is Otto Pfersmann, who I think nuanced the notion of hierarchy a bit in your original paper, and you don't need to go back to that. We remember the D and the H and the other letters.
So, yes, 10 points, rather quickly.
Then it's going to be a list.
Yes, I have said that unconstitutional constitutional amendments is an expression which has no meaning, because And therefore, I propose to replace it, to reconstruct it in another ways. I don't think it's totally meaningless. It's only meaningless if we don't restructure it. That is, what that means is, in fact, whether in a given legal systems there are supra-legislative, non-equivalent polymorphic norms, either positive or negative. But then still, even if we have some such thing, the real problem is whether this distinction in the way norm production is structured, positively or negatively, implies the possibility of courts or other organs to check the lower against the higher. And there is, my thesis is, there is no logical link between the differentiation of procedures of norm production or the interdiction of norm production and the very possibility of a check. This is, therefore, the real problem, which we have not answered yet. Second, textual unity is another problem than the problem of the differentiation of form. It's a sub-problem with which, indeed, Article 79, paragraph 1 deals. Third, interpretation. Well, I hadn't the time to go into this, but interpretation is not the problem of who decides. The problem of who decides is a problem of the normative hierarchy, attributing competences to certain organs. The problem of interpretation is what provisions formulating prescriptive sentences mean. This is a problem of analytic, applied philosophy of language and linguistics. It's a problem of meaning. Because the question is, and this is a question of meaning again, who is entitled to decide, and who is entitled to decide is enshrined in certain provisions. So the problem is, how do we interpret as a problem of meaning who is entitled to decide? At least we should keep both questions separate, even though, unfortunately, both questions are termed interpretation in most of legal scholarship. But unfortunately, this is a confusion, a terminological confusion. Inconsistent norms. Well, we have thousands, we have oceans of conflicting norms in all legal systems, and especially in constitutions. Constitutions adore conflicts of norms. Fundamental rights are catalogues of conflicting norms. That's why the European Union adopted hundreds and hundreds of provisions where you have everything. Everything is in conflict with everything else. So the real problem is, how is the resolution of conflicts legally organized? And this, again, is a problem of interpretation. Democracy. Democracy is nothing else but a way of organizing norm production. And the difference between 18th century and 19th century and 20th and 21st century democracy is that democracy today is a hierarchically differentiated structure of norm production, including, of course, restrictions to norm production by representatives. This is precisely what is interesting about it today. Supra-constitutionality brings us back to unconstitutional constitutional norms. So I think this is just a terminological confusion. The problem is whether above ordinary lawmaking, primary legislation, we have different forms. So I think it's, in order to avoid confusion, it's better to say superior constitutionality rather than supra-constitutionality, which always includes this idea that above the highest there is something higher, which of course is not very leading very far. What has Kelsen said about the prohibition of amending constitutions? Well, I don't agree with Claude Klein's exegesis of Kelsen, but of course this is only an exegetical problem. I think, but the rather interesting issue about it is that we have to distinguish the normative issue as to whether a constitution wants to be eternal. Who doesn't want to be eternal? We all want to be eternal. All religions tell us that we are eternal, but we... But the problem, whether this really prevents revolution, is a false question, because this is a problem of facts. What legal knowledge can provide is just to qualify revolutions as revolutions in the legal meaning, that is not traceable to rules for rule modifications. Okay.
Okay, I was generous. Thank you very much. Dr. Weinthal?
First, there was a question about the whole system of free-track democracy and internal clauses. Is it really a new system of government? Is it a new, another regime? It's not democracy, which the power is in the hands of the people. It's another system of government. Well, I believe that this touches the basic legitimacy problems I have mentioned earlier, the pre-commitment and the intemporal pre-commitment. How can one generation forbid another generation to change basic elements of the nation? I believe that the Constitution is not a deviation from democracy, is actually an institute that guards democracy, a part of the militant democracy, you said earlier. You have to protect democracy. It's not, we in Israel, since our first days, we got used to live in a democracy, but it's not something you should take easily. This is something you need to fight and you need to protect, and one method to do it is to put eternal clauses in the Constitution to ensure that democracy will be really eternal, because we believe it is the last chain in the evolution of systems of government. Another questions regards the way how one generation can forbid another generation to change the elements of the nation, and how eternal clauses can be justified. I just want to say that, and the third track especially, I just want to say that I distinct between a particular recipe for social evolution and human progress than to a universal one. When we recognize particular founding values, they are not enjoying the eternal status of the Constitution. The three-track democracy only suggests that because they are so fundamental, we need to take them seriously and to set some requirements for the process we want to change them. And Parliament, we know how parliaments are working. Sometimes they are influenced in a sort of way, and their interests sometimes are short-sighted and not long-sighted. And that's why I said earlier that Parliament is not the legitimate body for the reincarnation of the constituent, of the original constituent power, and we need to think of a third track that will take those requirements into consideration. The other questions was about how the third track would be operate in the United States, because we need to remember that after the victory in the Civil War, the very important amendments, the 13th and the 14th, were not formally introduced, and the South has to agree to those amendments. This is a typical example of how the regional constituent power can be operated not institutionally and formally, but in a spontaneous way. The first time the original constituent power is operated in a nation can be either institutional and formal in the formation of constituent assembly, but it can also made spontaneously by the collective effort of different institutes in the democratic society. I believe in Israel, the original constituent power was a collective effort of several institutions, of course, parliament, with the basic law, the court, and other social institutions. So the 13 and the 14 is not a formal amendment, but a spontaneous act. Bruce Ackerman assessed this constitutional amendment as a second revolution in the United States history. I perceive them as an act that the United States as a whole had to take to correct a collective dissonance that was introduced by the slavery institute in United States democracy, and was corrected, not formally, in the 13th and the 14th Amendment. It was an act that was legal because it strengthened democracy and not weakened it.
All right. Thank you.
Okay. Thank you very much.
Thank you. And Claude Klein.
Well, all religions have a prayer saying, "Take pity on us." I take pity on you. I will just say one sentence regarding what Julia said regarding the generation. Okay, the problem with that argument, which is a very good argument, how can one generation bind another generation? This argument has been used by Jefferson already for the Constitution itself. That means, in other words, that it's not only true, of course, for an attempt of having an eternal constitution. It's even true for the ordinary way of defending a constitution. And the truth is that the American Constitution is actually almost non-amendable because of those difficulties. So the argument goes only for that and for that.